Good morning, everyone, and thanks for joining us for the first in Denton's series of webinars navigating the workplace of the future in 2022 and beyond. My name is Peter Stockberger. I'm a partner with Denton's Global Employment and Privacy Groups, and I'm happy you could join us today alongside of my colleagues, Sandy and Sarah. Today, we are going to be diving in to new California laws that took effect in 2022. So get you up to speed on everything that's taken effect since January 1. And we're also going to dive into a new area of California privacy law that's going to significantly impact employees and job applicants throughout our state in 2023 and how you can prepare for that this year. So before we dive into the agenda and do some brief introductions, I do want to provide a brief message about CLE credit. The webinar window that you have open right now has to remain open for the entirety of the program, and it has to be the only window on the forefront of your screen. So WebEx, the platform that we're on, can detect if you minimize the program or if you use the computer outside of the webinar software. So this would prevent you from getting CLE credit. So it's important to keep that window open. One other important note, if you have a New York or New Jersey license, please be sure to listen for a code word we will provide you during the program. When you're prompted, you'll need to enter that code into the Q&A box on the screen in order to get your CLE credit. So if you're New York or New Jersey licensed, pay attention for that code word. With that, I'd like to turn it over to my esteemed colleague, Sandy McCandless, and Sarah Syed to provide the brief introductions about themselves and their practice area, and then we'll jump right into the program. So Sandy, over to you.
Hi, I'm Sandy McCandless. I reside in the San Francisco Bay Area. I'm an employment partner at Denton's. I practice in a wide variety of employment areas, both litigation and providing counseling on an ongoing basis to clients, work with clients on executive employment agreements, non-compete situations, etc. I also facilitate the handling of employment matters across the globe for international clients. Sarah, would you like to introduce yourself?
Morning, everyone. Thank you, Sandy. I'm Sarah Syed. I'm a counsel in the employment group in Los Angeles. And like my colleagues, Peter and Sandy, I am actively involved with my clients, providing day-to-day advice and counsel on all aspects of the employee lifecycle, all the way from the top C-suite executives down to our workers on the ground. And I think I am kicking off the presentation today. Next slide, please, Peter. So one of the new updates in California is with respect to the California Family Rights Act. And while, so it's expanded the right of employees who want to take leave by now including parents-in-law as a definition of a family member. Before 2022, it was limited to a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner. But now we've added parents-in-law to the mix. And while this might seem just kind of a minor change here, it really is a reflection of how California is expanding leave in the state. As some of you may be aware, last year they expanded CFRA to apply to 5 employers with 5 employees or more. And so that significantly impacted who was a covered employer under CFRA. And that's not just 5 employees in California, that's 5 employees anywhere in the country. So we've brought a lot of employers into the fold with the new expansion back in 2021. And this is just another step in providing expanded leave coverage to employees in California. As a sort of background to this addition of the parents-in-law, what the original bill, they wanted to just make it a designated person, and that was somebody the employee just identified at the time that they needed leave. And so that's a much broader coverage by just having the employee being able to designate a person who they want to take leave for. But because CFRA was expanded so significantly last year, just by applying to employers with only 5 employees or more, they decided to step back from that, and then they just added parents-in-laws to the definition of family member. Another aspect under CFRA is the mediation option that the Department of Fair Employment and Housing, which is a California agency that governs regulation of CFRA and some other California employment laws, is that they've now, the department itself is now required to notify an employee in writing of the mediation requirement under the DFEH's Small Employer Mediation Program. A small employer is defined as somebody with 5 to 19 employees. And so the DFEH is required to notify the employee of this program before the employee goes ahead and files a civil action. What's important to note here is that if the employee fails to contact the DFEH prior to filing a civil action, the defendant in the case that is ultimately sued can go back and stay the civil action and the litigation and make sure that the employee completes the mediation as part of the Small Employer Mediation Program. So it is an added step for the employee. It gives a little bit more time for the defense to, prepare for litigation. And also, to the extent mediation is successful, and I've had success in doing mediations both with the DFEH and the federal counterpart, the EEOC, it can help resolve, claims and disputes before we get into protracted litigation and significant costs. Next slide, please, Peter. So, of course, it wouldn't be an employment update if we didn't talk about COVID. So as you all know, last year there were some COVID notification requirements that California had enacted with respect to employers, meaning what happens if somebody in your workforce tests positive for COVID. So last year, the notification requirements for the employer were that only if an individual in the workplace was exposed to someone who had COVID-19, they were required to notify the affected individuals within 1 business day of the employer receiving notice of the positive case. As of the 1st of this year, they've changed the notification requirements. And so now it only needs to be provided to individuals who were on the same work site as the individual who had tested positive during the infectious period. So what is the infectious period, of course, is what we all want to know. And that is based on CDC definition, which is for asymptomatic individuals, it's the 10 days after the first positive test. So you have the asymptomatic employee has COVID, but is just asymptomatic. And for symptomatic individuals with COVID, the infectious period is 10 days after the onset of symptoms and after resolution of a fever for at least 24 hours and improvement of other symptoms. So this gives the employer a lot more time to notify affected individuals. Before it was, 1 business day. Now we've got a 10-day period in which to make that notification. And like the previous requirements, the worksite excludes anyone who's working remotely or working alone, for example, at their home. So, we're not required to expand the notification to employees outside the worksite. And with respect to outbreak notices, if you recall, outbreaks were defined as 3 or more lab-confirmed cases of COVID amongst workers who live in different households. So that's what an outbreak is as defined under the law. And before, we were required to give notice within 48 hours to the local health agency. Now it's 48 hours or 1 day later, whichever is later.
Hey, Sarah, one quick point on these new rules around the COVID workplace prevention program, which are promulgated by Cal OSHA. I think these new notification standards, it's also to view it in context, Cal OSHA is consistently reviewing these emergency rules and this workplace order. And with the CDC's new guidance on masking, with different science coming out around infectious period, moving into the summer months. I think we can anticipate, and Sarah, let me know if you agree. I think we can anticipate Cal OSHA making even more changes, likely in Q1 and Q2 of this year. So this area around your COVID workplace prevention program, I think it's an area really to watch and consistently stay on top of Cal OSHA's movements, because this notice period, masking requirements, is there going to be a separate standalone vaccine requirement, which we're seeing bills in the legislature proposed? So it's really a fast-moving area of the law right now in California, even though I know everybody's tired of talking about COVID. But it's a little context, I think, around this notice requirement this is one of many areas that's quickly changing.
No, I agree, absolutely. And I think, what's coming out of the governor's office as well with respect to, the masks being lifted in various places. Now, even schools aren't required to wear masks after March 11th. So it's evolving, constantly changing. So yeah, agreed. We can expect more in the next few months, if not sooner. One other aspect of COVID-19 that came out earlier this year is recall obligations. So this only affects a certain subset of employers, but pretty significant in terms of what employers have to do in terms of recall. So this has to do with employers who did, layoffs or, reductions in force as a result of COVID in the hotel industry, private clubs that offer overnight lodging and have at least 50 guest rooms, event centers, with a huge number of seats, 50,000 square feet or 1,000 seats, airport hospitality operations, airport service providers, and janitorial, security, or other business services. So with respect to these employers, they are now required to offer employment to all of the employees that were laid off or reduced in force. And that begins this year and it extends through 2024. So the employees that are entitled to recall must have been employed by the employer for at least 6 months before they were laid off or subject to a RIF. Laid off, of course, due to COVID-19, and have held the same or a similar position that is now open and that these employers are now looking to fill. The more sort of onerous obligation on part of the employer is the notice requirements that they must undertake to comply with this law. So the open positions that are now available must be offered to that qualified group of employees within 5 days of establishing the open position. So this is now a requirement for the employers to go back, figure out who was laid off due to COVID, and make a list of all the open positions to compare who would be eligible for a recall based on the open positions. The offer needs to be made in writing and sent to the employee's home address. Email and text are also options. And then the employee, once given the offer to be recalled, has 5 days to respond before the employer can proceed with other employees or hire outside if they can't find anybody to fill within the qualified group of employees. This is a significant process. It's not going to permit the employer to just immediately hire somebody. They're going to have to go through this process to make sure that they're compliant. And in terms of the rehire and the recall of the employees, it can be based on seniority, particularly if there are multiple qualified employees who are eligible to fill the position. And of course, again, another COVID-19 employment law update for 2022, supplemental paid sick leave, which is a very recent in enactment. It just went into effect on February 19th, and it ends later this year in September. But a few things to note about this law. It operates very similar to how it operated last year, except now we've got 2 different buckets of paid sick leave. We've got one set of 40 hours for the various reasons that are listed in this 3rd column here. Quarantined under a government order, you're advised to quarantine by a healthcare provider, you're attending an appointment to get a vaccine or a booster or for a family member, you're experiencing symptoms or caring for somebody who's experiencing symptoms of COVID-19, seeking a medical diagnosis in connection with those symptoms, caring for a family member who is under a government quarantine, or a big one that affects a lot of people, school closures or other places of care that have been closed due to COVID-19. So you've got a bucket for that of 40 hours. And then you've got a second bucket of 40 hours if that employee actually tests positive or their family member or somebody they're caring for has tested positive. So you've got a total of 80 hours, and the buckets must be tracked separately, and they can't, so while the law went into effect on February 19th, it is retroactive to January 1st. So if somebody had taken time off for any of these reasons and was not paid, they can go back and get California supplemental paid sick leave for that time. Additionally, if the employer had already provided that in a paid manner and it met the amounts and the qualifications and the reasons for leave under California SPSL, the employer can get a credit for that and deduct it from those two separate 40-hour buckets. But it is an added or additional benefit. So if somebody or an employer had deducted this leave that is now available to employees from California paid sick leave, which is independent of COVID, then that bucket or that balance of COVID, of California paid sick leave must be credited back. So it has to be tracked separately. It's a different benefit. It's independent of any other leave available to the employee. So it's very important that employers update whatever tracking systems they have in terms of, how leave is designated. And additionally, it has to go on the pay stub, similar to California paid sick leave. And what's different about this pay stub requirement is that it's not the balance of hours that are available, it's how much they've used, which is different from how California paid sick leave works. But yes, that is the end of my presentation, so I'll pass it on to Sandy. Thank you.
So before I begin, I wanted to add a comment to what Sarah said about mediation. Both the Federal Equal Employment Opportunity Commission and the California State Department of Fair Employment and Housing have mediation programs. Given how litigious California employees are and the fact that if an employer ends up in a jury trial, sometimes the damages are in the millions of dollars awarded by the juries. There's a great benefit to agreeing to mediation early in the process and finding out what the employee is really claiming, getting what we call free discovery about the claim, and deciding whether or not you want to settle early on and avoid actual litigation. My primary topic this morning is the new documentation requirements and prohibitions of California law. California Senate Bill 331 was signed by the governor on October 7th of last year, and it amends the Code of Civil Procedure and the Government Code. And this bill will have a tremendous impact on the use of employment documentation of all types in California. And you as employers employing people in California will have to now review your existing employment documentation for revision and compliance with the new law. And the new law has 3 impactful sections. This slide addresses the first section, which is that it expands the prohibition on confidentiality clauses in actual settlement agreements. A settlement agreement meaning an agreement in a lawsuit or in a claim or before an administrative agency. Previously, under existing California law, a settlement agreement could not include a prohibition on disclosure of factual information regarding claims made in a civil or administrative proceeding alleging sexual harassment or discrimination. This was a response to the Me Too developments in the country. But now there is a prohibition on disclosing prohibiting the employee from disclosing factual information regarding any type of protective claim. So in your settlement agreements of lawsuits and administrative proceedings, you can't have a non-disclosure agreement prohibiting disclosure of the facts underlying the matter. However, you can still preclude disclosure of the amount paid. This is actually a big development for settlement agreements. Next slide. Thank you. The next of the three provisions relates to broad-based employment documentation, everything from offer letters to employment agreements and employee handbooks and policies. It has always been, in many respects, unlawful as a condition of employment to require a release of a claim or right in conjunction with a raise, bonus, employment, or continued employment. My view is that that's always been prohibited. But now the employer cannot require signature to a non-disparagement agreement or other document whose purpose or effect is to deny the right to disclose information about unlawful acts in the workplace. So if you have provisions that say that the employee cannot disparage the employer, those provisions are unlawful under California law. They have been prohibited in many respects previously under the National Labor Relations Act, which governs not only union employees, but also employees in the workplace who discuss wages, hours, and working conditions. But now California law prohibits broad non-disparagement provisions. If you do have such a provision, you have to include a statement: nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct you have reason to believe is unlawful. You must now have that statement in conjunction with a broad non-disparagement provision. Next slide.
Hey, Sandy, a brief question on that. So this non-disparagement prohibition and that clause, is that required for both severance agreements, separation agreements, as well as for employment agreements?
Well, there's a new provision for separation agreements. So I would say yes, but let's look in a moment at separation agreements themselves. But what does all this mean in practical terms? Because it sounds like a lot of verbiage. And I will say that I predict that there will be a lot of litigation about what these new laws mean, and it's not entirely clear. But the broadest of the rules, which apply to all employment documentation, what does that mean in practical terms? So review your existing documentation with legal help to determine whether anything in your documentation arguably has the purpose or effect of denying the right to disclose information about unlawful employment acts. So any broad non-disparagement provision is going to do that. Can your provision be read to restrict employee ability to disclose information about workplace conditions? If so, is it worth having that language, in which case you have to put in the disclaimer: nothing in this agreement prevents disclosure of information about unlawful acts such as harassment or discrimination or other conduct you believe unlawful. I mean, employment handbooks have typically had, obviously must have, comprehensive anti-discrimination and harassment provisions. But this rule is now going to require this type of language in a lot of other employment documents, such as employment offers, if you include non-disparagement provisions. So should you just remove your non-disparagement provisions? There'll be much interpretation and argument about what this standard means as the law evolves, but the word disparagement or non-disclosure, now those are words that you're going to have to review in context to decide whether or not they violate California law. And one of the things this demonstrates here is how different, in many respects, California law can be from the laws of many other jurisdictions. Next slide. Go ahead,
Cindy,
Peter.
yeah, an area where I think this might also create a practical challenge is in areas of agreements that have non-solicitation provisions talking about not going after competitors or current clients. And so you can imagine a scenario where an employee or former employee goes to a client in violation, let's say, of a carefully tailored non-solicitation provision around current clients and tells that client, I was subject to harassment. These are bad actors. You should come with me and my business. So you can see where the overlap between trying to protect your business and competition versus restricting disclosure of allegations of workplace harassment. It's sort of a three-headed snake that can really come around. So I think your advice on carefully reviewing the agreement in whole and thinking about how this plays out in various use cases makes a lot of sense, because that's an area where I think this could really become a challenge.
Well, and the rules on employee non-competes and non-solicitation of customers and employees are also incredibly different in California and very restrictive, and employers need to be aware of what the differences are in that arena as well. We recently had a situation for an employer where some language had been used that I believed was okay, but it hadn't been written exactly the way I would have written it. And so as the matter, it wasn't a litigation matter, it was a post-employment communication matter, and we tailored the language to California law as we proceeded with further communications to make it clear that California law wasn't being violated. So Peter had asked about, well, how are actual release agreements different? What's the law, the new law there? And I'm making a distinction here between the separation agreements that employers routinely give employees to sign in return for separation pay and release agreements in the context of a lawsuit or actual claim. So a separation agreement cannot prohibit, this is your severance agreements, can't prohibit disclosure of information about unlawful acts in the workplace. If you have a non-disparagement provision in your severance agreement, it must include nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace. So common non-disparagement provisions may in fact disappear from employee separation agreements in California. And in the last 2 weeks, I have taken out-of-state release agreements and removed the disparagement provisions in general, but I left in non-disparagement of company business activities. I think that's still allowable. That's my view. And so it's okay to have a non-disparagement provision, but my view is that you must now limit it to company business activities unless you're willing to put in a positive statement that you can disclose information about acts you thought were problematic in the workplace, which essentially destroys the intent of a non-disparagement provision. Let's go on to the next slide. Okay, so
if I can just go back 1 second, Sandy, back to Peter's point when we were talking about the interplay between those provisions, non-solicits, non-competes, however they are tailored appropriately. But I think one other way to sort of help protect the business is to, in conjunction, beef up existing confidentiality and non-disclosure of confidential information and trade secret information, because my understanding is that law didn't touch that aspect of what employers can do and how they can protect their confidential information. So beefing those up at the same time can really help serve sort of a holistic approach when we're dealing with separation settlement agreements.
yeah, absolutely. There too, of course, the requirements of California law have to be considered. Often confidentiality agreements are coupled with invention assignment agreements, and there is specific California law that must be in any confidentiality agreement that includes invention assignment language. So thanks for that addition, Sarah. California has a host of record-keeping rules that don't exist in other states. The employers must now maintain and preserve personnel records for at least 4 years. We recommend longer. There's a new rule that workplace postings are still required, but it is compliant to provide postings electronically to people who work remotely. There are many wage and hour record keeping rules in California. In California, employers can face millions of dollars in penalties for technical violations of wage statement law or tracking of time law, such as lunch periods for California non-exempt employees. Classification of non-exempt employees as exempt, and the use of independent contractors continues to be continually challenged and a problem for California employers of California employees. Two recent developments are shown on the slide. In Donahue, it was held by the California Supreme Court that rounded time punch entries are not allowable to comply with the required time records showing the beginning and ending of required meal periods in California. You are absolutely to track the timing of meal periods for California non-exempt employees. And another new development is the Lowe's Hollywood case, whereby if lunch periods are late, short, or otherwise non-compliant in terms of your timekeeping and when employees are taking them, there's a 1 hour penalty that's due, and the California Supreme Court has now held that penalty must include certain bonuses and commissions, which are non-discretionary and paid to employees. These time calculations are incredibly difficult, and it's almost impossible to do everything correctly. So I recommend to you that you figure out if you're complying with the California record keeping requirements in full, and if not, changes are recommended to be made. Next slide. I'm a big believer in employment documentation. And one of the reasons has always been that California Labor Code 1198.5 requires that current and terminated employees be provided a copy of their personnel records relating to their performance or to any grievance concerning the employee upon request. The employer has 30 days to comply. Most states don't have this rule. There's an Illinois act that actually has a much shorter time period, but I think one of the reasons California provides 30 days is this is not just the HR file, but all records pertaining to the employee's performance. An employee or former employee request for the file is a red flag for legal action. I've twice seen wage and hour class actions come out of that file request. California plaintiffs' attorneys are eager to see personnel files with no backup supporting the reason for employer action. It makes it an easy case if there's no documentation of why the employer did what it did. Understandable, persuasive documentation is critical to California employment actions taken against employees. I know that in many other states, it's not common to write employment documentation when terminating employees, but again, California plaintiffs' attorneys love to see those files that have good reviews and then an employer termination, and the only thing in the file is either nothing supporting the action taken or a release agreement that the employer tried to have the employee signed, which was unsigned, leading to a claim or litigation. So record keeping is critical, and that includes persuasive documentation of how you decide and why you decide to engage in any adverse action against an employee. Peter and I had talked about wanting to address very quickly the topic of mandatory arbitration. And mandatory arbitration is a provision requiring an employee to arbitrate a claim rather than having a jury trial. And mandatory arbitration provisions, you can't have a jury trial. Instead, you go to arbitration before a private arbitrator. Those provisions are highly controversial in California, although we see them. I'm an employment arbitrator myself. California has a law on the books prohibiting mandatory arbitration of employment disputes in some cases. That law may be preempted by the Federal Arbitration Act. That question is before the courts right now. And most recently, the U.S. Supreme Court granted cert, agreed to hear the question of whether federal law requires enforcement of employment arbitration in California for alleged violations of the California Private Attorney General's Act, PAGA, which provides for civil penalties per pay period per person for highly technical violations of California law. And PAGA is another reason why it's so tricky in California, that if you fail to comply with some of the many rules, you can find yourself in court with a very, very expensive employment proceeding. So, Peter?
Yeah, thanks, Sandy. I think that Supreme Court case, looking at that issue, can you compel arbitration on PAGA disputes, which is a civil enforcement action, is going to be a really fascinating case to watch and will have a significant impact on the use of arbitration clauses in employment, because that's a real pain point for a lot of organizations right now on the PAGA disputes.
And that's the Viking River Cruise case, which you're going to be hearing that name.
That's right.
I have a lot of clients that are literally just waiting for that before they decide what to do. So it's going to be a game changer for many, many businesses.
Well, Sandy, thanks for the notes on the record keeping. It sort of ties directly into the developments in data privacy law in California, which go directly on data record keeping and notices. But before we jump into a look at data privacy law in California, I do want to provide the CLE code word for folks licensed in New Jersey, and New York, or Pennsylvania. You can type it into the Q&A box. I'll give you a moment to do so. And just as a reminder for everyone as well, if you do have questions throughout, you can populate them in the Q&A box. We'll address them before the end of the program or at the end of the program. So the CLE code word is sunshine. All right, now turning to a look ahead at the data privacy landscape in California. In a new law known as the California Privacy Rights Act, the CFRA, that is taking effect on January 1 of 2023. And this law is going to directly impact the collection, the use, the storage, the sharing of employee, job applicant, and contractor information of California residents. Before I jump into the CFRA and what it requires, I think it's first helpful to just get a snapshot of the US data privacy legal landscape so you understand where the CFRA sort of fits into this puzzle. There is no US federal data privacy law that governs data privacy across all individuals in the US. That makes the US different than most global jurisdictions, such as Europe, which have standard uniform data privacy laws, such as the GDPR in Europe or other laws throughout Asia and throughout Latin America. In the US, our data privacy laws are fairly segregated by industry. So at the federal level, we have data privacy laws that govern financial institutions, such as the GLBA, Fair Credit Reporting Act. These regulate banks, lending institutions, insurance companies. You have US healthcare privacy laws that govern hospitals and business associates. We all are familiar with HIPAA. And then you have a general unfair business practice regulation at the federal level governed by the FTC Act and that law. So the FTC will enforce the law against companies who make misstatements in their privacy statements or where there's a security breach. There are some bills pending in the legislature at the federal level to create a uniform federal data privacy law. But as anyone following politics at the moment can tell, I would be hard pressed to say that there will be much development coming out of Washington in the next couple of years on this topic, but we'll wait and see. At the state level, that's where we see more action in the data privacy space. All 50 states have their own data breach notification law that relate to California residents. That includes California employees on the data breach notification side. We have sister counterparts to HIPAA. We have child privacy laws, biometric. The CPRA, which is taking effect next year, and the CCPA, which is in effect today, those fall into this bucket of consumer privacy laws. These are omnibus data privacy laws that are being passed by the states that give affirmative rights to residents of those states over how their data is collected, notice around what's being collected, and to control how that data is being used. So that's where the CPRA fits into this sort of US landscape. And before we jump into the details around the CPRA and how they're going to impact the employees, I did want to just give you a sort of procedural history to give you some context of how we came up with this law. Currently, the law that's in effect today is known as the CCPA. That's the California Consumer Privacy Act. That law was passed and signed in 2018. It took effect on January 1 of 2020. That law has very limited effect on California employees. California employees under the law today are only entitled to receive notice at or before the point you collect their personal information. So during onboarding, during the job application process, if you're a business subject to the CCPA, and I'll talk to you about what are the thresholds for that coverage, if you are a covered business, you're required to provide a notice. It's not consent. It's not giving people the right to delete or the right to request their data. It's notice only. The Attorney General's office is charged with enforcing the CCPA. They began enforcing it in July of 2020. They have been enforcing the law. I've represented several clients who have received non-compliance notices from the AG. The good news is there's a 30-day cure period right now. So the AG has not brought a single civil enforcement action in court. It may do so soon, but it hasn't yet. And there have been notices and compliance letters that have gone out. The new Attorney General in California, Rob Bonta, has increased enforcement under the CCPA. They're focused on loyalty programs. They're focused on opt-out rights. So they're trying, I think they're increasing enforcement starting this year. Where this is all changing is there was an amendment to the CCPA passed by the California voters in November of 2020. And the amendment is the new law that takes effect on January 1 of 23. The amendment is called the CPRA. So the acronyms are going to confuse everybody. The new enforcement agency is called the CPPA. So they just can't come up with 4 different letters. But the CPRA is what we passed as voters in 2020. That's what's going to take effect on January 1 of 23. And here's what's going to change for you as a California employer. Right now, employees, job applicants, and contractors are exempt from 95% of the CCPA. That's the law today. They're only entitled to notice. That exemption, by operation of statute, is going to expire on December 31st of this year, meaning unless there is a legislative amendment stating otherwise, employees, applicants, and contractors will be entitled to the full suite of rights under this law. That is the right to know what data has been collected about them, the right to request that it be deleted, the right to opt out of it being shared or sold for advertising purposes, and the right to exercise those rights free of discrimination. Now, there's a question in the Q&A box saying, I thought this exemption was going to continue. Aren't there exemptions already being passed? There are approximately 8 bills that were introduced in the legislature the week on February 18th, which was the final day to present those bills, seeking to extend the exemption for employees, applicants, and contractors to either 2026 or indefinitely. And that is because the business community saw that this exemption was going to expire, and there's been a lot of effort to try to get an extension. Now, those amendments, based on the current legislative calendar, those amendments don't have to be passed out of their respective chambers until August, and they would be signed into law in October. So we won't know whether there's an extension until the fall. But in my opinion, I think there will be some real challenges in getting those extensions passed. And here's why. The Prop 24, the CPRA that the voters passed, it's not a legislative amendment, it's a ballot initiative. So the law that's taking effect in 2023 is a ballot initiative. And in the law itself, it says there can be no legislative amendment unless it furthers the privacy interests of California residents. And an exemption for a group of California residents, I think, runs up directly potentially against that legislative language. And so when these amendments go through the Legislative Council's review within the legislature, I think there could be a real battle. So it's a space to watch. But as it stands now as an organization, you have to be thinking about rolling out a privacy program that complies with the CFRA effective January 1 of 23. This new law is going to be enforced, and it's going to be enforced aggressively because there's a new enforcement agency called the California Privacy Protection Agency that is being stood up under the CFRA. It has 5 board members. It's headed by an academic from Berkeley. It's got a very seasoned and privacy-focused executive director who came from the FTC. They are staffing up. They have a budget. They're in the midst of drafting regulations, and they will start enforcing the law on July 1st of 2023. Their draft regulations, they just recently announced that they're anticipating they'll be released in Q3 or Q4 of this year. But something very important to keep in mind about enforcement going into 2023 is there will be no cure period. There is no right to cure. There will be notice of noncompliance, 30 days to cure. You will get a notice and you will have to appear at a hearing before the CPPA. And they have the authority to issue penalties of $2,500 per individual per violation, up to $7,500 for any intentional violation. So you can imagine a scenario if you are dealing with hundreds or thousands of employees or customers and you're not providing adequate notice and the CPPA investigates, they have significant authority. Whether they're going to exercise that authority remains to be seen, but they have significant penalty authority and there is no cap on penalties. So you can imagine that this agency is going to be looking to make a splash. So we're keeping an eye on this agency. We're participating in the rulemaking process. But my advice for organizations now is to start mapping your employee, applicant, and contractor data and start thinking about rolling out an employee, applicant, and contractor privacy program for 23. So briefly on this slide, this just gives you a sense of who's a covered business, because I think that's the number one question. Well, am I even going to be covered under this law? And the definition of a covered business under the law today is you have to be doing business in California, you have to be for profit, and you have to hit one of 3 thresholds. 1, 25 million in gross annual revenue. That's worldwide. If you don't hit that threshold, it's are you collecting the personal information of 50,000 or more California residents annually? That number may seem high, but in actuality, because personal information is defined to include things like IP address, it really only breaks down to roughly 137 unique website visitors daily. So if you have a significant presence online in California, you could easily hit that number on the 50,000. The good news is, for a lot of small and medium-sized businesses, is that in 2023, that 50,000 number is changing to 100,000. So that threshold is increasing, but the 25 million gross annual threshold remains. The third threshold, if you don't hit those first 2, under the current law today, the question is, do you derive 50% of your gross annual revenue from selling personal information? And selling is giving somebody's information to a third party or making it available for some commercial value. So you can imagine scenarios where in advertising or in other instances where that third party may monetize the data, that could be a sale. That's also changing under the new law in 2023, because a lot of organizations say, well, I don't sell data, so I don't hit any of the 3 thresholds, so I'm not covered. But under the new definition for 2023, it's not just 50% of your revenue from selling, it's also from sharing personal information. And sharing is defined as cross-contextual behavioral advertising, whether for money or not. So if you engage in any digital advertising where you're tracking user behavior and you derive 50% or more of your revenue from that online advertising, that will capture you ostensibly under this new threshold. So those are the definitions of a covered business. If you are a covered business, thinking about it now, you have to be thinking about the obligations you'll have towards employees, applicants, and contractors, assuming that an exemption does not get passed in the fall. And what that means is that you'll have to stand up an online privacy policy for those individuals. You'll have to have robust notices. You'll have to have internal policies and the ability to respond to requests for access to data, requests to delete data, requests to not share the data with third parties. And Sandy, to your point about document retention, the new rules around 4-year period on employee records, this goes directly to the request for delete. So you can imagine a scenario here, and this is sort of the worst case scenario that everyone thinks about is, oh, an employee sends a request to delete their personnel file. Well, the law builds in an exception to that if you are required to keep the record pursuant to applicable law. It also has an exception for if you need to keep it for internal purposes that align with the original purpose for which you collected it. So Sandy, you made a comment, it's a 4-year period of statute of retention requirement. We recommend you keep it longer. Under the new California Privacy Rights Act, if you're going to keep it longer than the statutory period, organizations have to think about why. Why are we keeping it longer? What's the business purpose for keeping it longer? And that's going to require you to dig even deeper into your data retention program itself and say, if we are keeping data beyond legal retention periods, why are we doing it? What's the business justification? And have we given notice to the individual that we're going to keep it for that long and for that reason? That's really the core of the CFRA now. It's notice, and it's describing how long you're going to keep information and ensuring that businesses aren't over retaining information. And that's going to be a new avenue on the employee HR side. You know, it's data privacy is not usually a function on the HR side. So coordinating HR and the data privacy team is going to be critical here. So key takeaways for the CFRA, and then Sandy and Sarah, I'm going to toss it back to you for some kind of key takeaways as we close out the webinar. But key takeaways here under the CFRA, one is we've got to watch these legislative amendments. It's obviously going to be critical to see if there's an amendment that exempts this group of employees, applicants, and contractors from the rest of the law. But a lot of organizations can't wait until October to make changes. You have code freezes internally. You need to get budgets approved. So my key takeaway here is start thinking about strategically, regardless of whether the CFRA pushes you into an employee applicant privacy program. Should you be creating a privacy program anyway? Is it the right thing to do to give your employees and applicants more notice about data that's being collected, more disclosure about how long data is going to be retained? You know, from a best practices transparency perspective, I think there's a lot of advantages to that. So that's one item that you have to start thinking about is planning now, strategically planning now about your strategy and your goals. The other part of planning are the nuts and bolts of planning, putting together a privacy statement, mapping out the vendors you use to figure out how notices will be delivered. For example, requests for access. Well, many organizations use platforms like Workday or ADP that have self-service modules where the employee can log in and really see all of their employee data. They can see their benefits information, they can see their payroll information. So how do you build in those processes into responding to requests? So thinking through all the modules that are available, your existing contracts, notices that would be going out, takes a lot of planning. And by experience with the CCPA, it can take a lot of time and effort internally. So starting that planning process now is really critical. One other key takeaway is as you are reviewing your notices for contractors, take this opportunity to audit your contractors and determine whether they align with the ABC standard in California. You know, if you're going to be looking at, are we going to give these folks notices, look at that agreement and that contractor now and use the opportunity to determine whether you need to reclassify those individuals. You know, reclassification always raises red flags if you do it on a large scale or even on a small scale. But if you are doing it in the context of reviewing a new privacy law and developing notices, sometimes that can give you a bit more of an umbrella to engage in that audit practice. So it's a good opportunity to do 2 at 1. And then the final key takeaway is around security. The law as it stands today and the law as it's going to stand in 2023 give all California residents, regardless of your status with an employer, give you the right to sue your employer if there's been a negligent data breach around your data. And in California, the California Attorney General in 2016, who was then Kamala Harris, issued a report that said baseline reasonable security in California is alignment with what's known as the CIS controls. That's for the Center for Internet Security Controls. It's a set of 18 cybersecurity controls. It's available online. So you should be measuring how you are storing applicant, employee, and contractor data and collecting it against those controls to see if you've got any security gaps that would introduce potential liability under the law today and under the laws it's going to change in 2023. So it's actually a pretty straightforward practice. You take the spreadsheet, you compare your current controls, it'll tell you if you've got a gap under the CCPA. There's roughly 100 to 150 different class actions right now pending with CCPA claims. There's statutory damages of $750 per consumer. So those class actions can be pretty costly. So aligning security now makes a lot of sense. So those are the key takeaways around the CFRA. Plan now, think about it now. Sandy, I'll toss it over to you for a couple of key takeaways as you're seeing it as folks sort of navigate the new workplace of the future in 2022. Oh, Sandy, I think you're on mute. We couldn't have a good presentation
Peter.
without a microphone muted toward the end, right?
Yeah, thank you, Peter. I'll take my minute or two at the end to say that I do think that employers will continue to be required to maintain employment documentation more than 4 years. The new law references a minimum of 4 years. And since employers are required to provide documentation used to consider the employee's performance upon request, I don't think that destruction of those records is required or advisable. I mean, obviously, there may be situations where the CFRA and other existing employment laws seem to conflict. So we'll have to be maneuvering amongst the various laws as we decide how to handle employment records in the future.
Sarah, how about yourself? What are some key takeaways for the folks on the call?
Sure. So I think we all know COVID is not going away. And as Peter mentioned, things will constantly be evolving in the government, Cal OSHA. And so as many employers are planning return to work structures, hybrid practices, all of these COVID precautions, supplemental paid sick leave will all become relevant fairly quickly, and we just need to make sure we're staying on top of it, updating our policies and making sure we're compliant along the way.
Yeah, and I would say another key takeaway for me, putting aside the CFRA, which is going to be a significant change in the law, right now there are numerous pending bills in the California legislature around biometric privacy. And a lot of employers are collecting fingerprint scans at point of sale registers for retail locations. There's also a lot of organizations that are starting to use facial geometry in their training of sales individuals. There's software that is measuring whether a person is smiling too much or frowning too much in a presentation. And the use and the collection of biometrics, which includes facial scans, is increasingly going to become a focus in California. And I think one area to keep an eye on is that there's a bill that is going to try to move California toward the Illinois model, which would require express consent and express disclosure around the collection of biometric information at every stage within the collection process. So data privacy is here to stay. California is really, I think, trying to become the leader in that space, including around biometrics. And I think that's going to be an area to watch as we get into the fall. But for now, plan. Look at your retention period, per Sandy's comments. Look at your COVID policies and think about how the CFRA is going to impact your organization. So with that, that's the conclusion of our presentation. Thank you very much to everyone for participating. This was our first in a series of webinars on the future of the workplace, Stay tuned for an invitation for our next series, which will be focused on remote working, which will be happening in May. And we look forward to chatting with you then. Thanks very much and have a great rest of your day.
Peter, before you go, I sent you a chat. Someone was asking a question. I don't know if you have time for it.
Oh, yes. I don't have the chat open, but maybe you could read the question.
It says, have you repeat the name of the website where we can find the checklist of security control that was in the last slide?
Yes, certainly. So the name of the organization is CIS Controls. So this is the CIS website. If you just Google CIS Controls, it'll come up. And on their website, they have free Excel spreadsheets that list out the controls. Or you can just shoot me an email. I've got the spreadsheet, happy to share it with you and talk you through it. And last question, somebody asked, will the slides will be distributed after the webinar? They will, along with other CLE credit information. So you'll receive all of that in a follow-up email. And with that, thanks very much.